Hello. Yes, can you all hear me now? Apologies for the late start. I had a lag issue and I had to relog again, but I think now it's fixed. So, okay, without much ado, let me begin and say hello and welcome to Virtual Abilities Annual IDRAC Conference. My name is Diva Bars. Hello and welcome to Virtual Abilities Annual IDRAC Conference. My name is Diva Barcelos and I'm hard of hearing as a result of losing my hearing during my childhood. I prefer typing than using voice owing to my inability to understand voice accents. I've also combined with the fact I read lips in most of my interactions. I've been in SF for 13 years and I really love dancing and going to music concerts. I also enjoy participating in group discussions relating to mental health. In real life, I'm trained in counseling youth as well as education therapists to work with special needs children. Presently, I'm studying American Sign Language and Singapore Sign Language. I'm also working with a company that advocates for fairer practices in hiring of the deaf and creating awareness of the deaf community, their culture, practices, and accommodations for them. Today, I would like to introduce Jeannette Cox, who is a professor of law at the University of Dayton School of Law, whose research focuses primarily on disability and employment discrimination, even as she teaches courses in disability rights law, civil procedures, and statutory interpretation. Her topic today is titled Work Hours and Disability Justice. A very important aspect of disability justice is eliminating employment discrimination. I hope after listening to Jeanette, more of you may find better working opportunities and will also offer them to those who are differently abled. Audience, please hold your questions and comments to the end so as not to interrupt Jeanette, who is new to Second Life. Welcome, Jeannette Cox. The floor is yours.
Thank you very much, Diva, for your kind introduction. And I also want to thank Alice for inviting me and giving me an orientation to Second Life. As Diva mentioned, I am completely new to this environment, so thank you for welcoming me here. But I confess that I am definitely new to this, so please forgive any mistakes that I make because of my inexperience. I also want to thank Caroline and Electra for doing the transcribing today. Appreciate your fast typing skills, and I'll try not to talk too quickly, and if I do, please let me know. As Diva said, I am a law professor, and my research primarily focuses on how courts are implementing the employment provisions of the Americans with Disabilities Act, the ADA. And as you might imagine, I find a fair amount to critique in how courts are dealing with this important statute. And the project I'm sharing today critiques specifically how courts have been handling the ADA's part-time schedule accommodation. So to start, I'd like to share the text of the ADA's reasonable accommodation provision with you. And instead of really defining it, what the definition does is provide a list of examples of workplace accommodations that are reasonable. Not an exhaustive list. Obviously, there are a lot of things that are not on this list, like remote work, for example, isn't listed, but certainly is a reasonable accommodation, a lot of context. But what I want to highlight here is that part-time work schedules is right in the ADA, and it always has been. And it was even in the Rehabilitation Act regulations prior to the ADA. So for a very long time, the law has said part-time schedules are a reasonable accommodation. So if we take that text seriously, that means that an employer needs to provide a disabled person a part-time schedule if that's what they need, unless the employer can show the undue burden defense, which would require the employer to show that it would cause significant disability or expense. And because this is like directly in the text of the ADA, it's pretty clear that this is the requirement. Excuse me, I'm realizing I did not plug in the power cord for my computer, and I need to do that really quickly. My apologies. All right, didn't want to disappear on you midway through. So I was highlighting this text of the ADA explicitly says part-time schedules are a reasonable accommodation unless the employer can show significant difficulty or expense. And of course, there will be some jobs where the employer will be able to make that showing, that there will be a significant difficulty or expense. So you might think about an airline might be able to make the showing that they need a flight attendant to be able to do an entire long-haul flight as opposed to trading off in the middle of the flight. In those types of circumstances, there's actually a significant benefit of having a single person who can work a long stretch of time rather than trading off at some point. But for many, many other jobs, there really probably won't be significant difficulty or expense. So you might think of the example of a high school Spanish teacher. A lot of high schools would schedule a single person to teach, 6 one-hour classes of Spanish over the course of a day. Hiring 2 people to each teach 3 one-hour courses probably would not cause a significant difficulty or expense. There, of course, would be a small increase in the supervisory and administrative burdens that the school might have. But that small increase in cost is probably less than the cost of other listed accommodations like qualified readers and interpreters. So using this language, courts that faithfully apply the ADA's text have demonstrated that this is workable. So courts have concluded that part-time hours were appropriate for an auto parts store worker who was experiencing fatigue due to multiple sclerosis. Similarly, another court found that a sales representative who was experiencing fatigue due to his post-polio syndrome, also the law required his employer to provide a part-time schedule. And another case involved a sanitation worker who had a rare eye condition that prevented him from working pre-daylight hours. In that context, the court concluded, well, one of the types of reasonable accommodations that might be appropriate would be allowing him to just work the post-daylight hours instead of the longer shift that was standard. So these courts really demonstrate that the part-time schedule accommodation is workable, is appropriate in a lot of contexts, often does not actually cause the employer undue hardship. But my concern has arisen from the fact that unlike those examples I just shared, a lot of other courts have flatly rejected this part of the ADA. And instead of requiring employers to prove that a part-time schedule would cause significant difficulty or expense in order to refuse to do it, they simply allow employers to just not provide part-time schedules, period. And in many cases, just really kind of render this language in the text a nullity. So I'll give you an example of a court in its own words. One of the Court of Appeals concluded whether a company will staff itself with part-time workers, full-time workers, or a mix of both is a core management policy with which the ADA was not intended to interfere. Now that conclusion is pretty in conflict with the text on the prior slide, right, where the text explicitly has said from the very beginning of the ADA that part-time schedule accommodations are reasonable. It seems very clear from that text that the ADA was intended to interfere with an employer's refusal to have part-time employees. So this seems patently wrong, but this is one of the federal courts of appeals reaching this conclusion, and this conclusion has been very influential amongst a lot of different courts. And really, when they're making this conclusion, they just fail to acknowledge, right, that disability often is the reason an employee asks for a part-time schedule. And so when you say an employer can choose between whether to hire part-time or full-time, it's pretty similar to saying an employer is free to just reject people with disabilities, right? Certainly they're saying they're free to reject people with disabilities who need part-time schedules. So it often, that quote ends up sounding a whole lot, whether it's like the court is concluding whether a company will staff itself with disabled workers, able-bodied workers, or a mix of both is a core management policy with which the ADA was not intended to interfere. And that obviously is diametrically opposed with the ADA's purpose. So these obviously these cases concern me. It made me really want to dig in a little bit deeper and understand why courts are ignoring the ADA's text. I mean, these days courts generally claim to be very textualist, but this is an area where they are really directly contravening the text that's in front of them in the statute. So what I found when I dug into all of the cases is there are really two reasons courts provide for ignoring the ADA's part-time schedule accommodation, or maybe ignoring is not the right word, making it a nullity, like not giving it its effect, refusing to enforce it. So two reasons. Now, ultimately, I'll tell you that I don't think these reasons are the real reasons. I think they're actually unstated reasons that perhaps provide a fuller, more compelling justification to understand why courts are doing this. But let me first talk through what they say their reasons are. And in large part, my purpose for doing this is to show you how thin these reasons are, and how that's how much they don't really stand up to the statutory text. So here are the two stated reasons. The first stated reason is that courts should not be required to create a part-time schedule. They should only be required to provide part-time schedule accommodations when they have an existing part-time vacancy. In other words, courts, this rationale is sort of saying, unless the employer already has a part-time schedule, the part-time position already has to exist, and then the accommodation could be reasonable. And then the second rationale very much relies on the notion that full-time hours are essential and accommodations cannot change anything that is deemed essential. So I'll talk about each of those in turn. The part-time positions do not exist and employers shouldn't have to create them, is very much an idea that recasts what's actually going on, right? What's actually going on in terms of what the employee is asking for is often just asking to spread existing job duties across two employees. But courts always recast this as something that sounds a lot more onerous, saying, oh, you're asking the employer to create a new part-time position where none previously existed. And using that framework, courts have concluded that employers that only have full-time customer service positions can't be required to split that full-time position into two part-time positions, even if these are just basic answer the phone positions and it seems eminently reasonable and easy to split those into multiple jobs. In another case involving a high school science teacher, a teacher who showed that her school district had allowed other employees to work part-time, the court had a similar response of saying, well, this school does not have a designated part-time science teacher vacancy, and because there's not a designated part-time vacancy, it's not a reasonable accommodation. Now, this line of reasoning is really problematic. It ignores the part-time schedule accommodation. It also collapses the part-time schedule accommodation into another listed ADA accommodation. Effectively, the courts are saying you can only ask for a part-time schedule accommodation and get it when you're asking to be reassigned to a vacant part-time position. This conflicts with a basic principle of statutory interpretation. I teach my students that when you have a list of items, each of those items needs to be interpreted in such a way that they're each doing something separate. They each have independent meaning. And the court's violating this. Effectively, they're just crossing part-time schedule out of the statute because they're saying you can only get a part-time schedule when you are effectively being reassigned to a vacant part-time position. So that violates the statutory interpretation principle. It also violates the legislative history of the ADA, which makes very clear that these are two distinct types of accommodations. Both the House Committee report and the Senate Committee report, when the ADA was enacted, made very clear that these are two distinct accommodations. They wrote one whole paragraph about the part-time schedule accommodation, discussing how standard work hours are a barrier to people with certain disabilities. And then an entirely separate paragraph, they say reassignment to a vacant position is a different, separate accommodation. But despite that, courts are taking this approach to justify denying part-time schedule accommodations. And this approach has become so entrenched that in June of last year, a Court of Appeals validated an employer who had a formal job sharing policy that refused to allow a disabled woman to job share. And it was a pretty extreme example because this job sharing policy was in writing, formalized. She, of course, had done everything she needed to do to find a partner and apply under the policy. She showed that the employer had allowed a lot of other people to job share, work part-time pursuant to this policy. And so it seemed like this was a classic situation where a court should view her job share request to work half-time as a reasonable accommodation because the employer had done it many times before. But using this part-time position doesn't exist framework, the court reasoned that there was no vacant part-time position until the employer approved the job share request. And because the employer refused to approve the job share request, the court concluded that the part-time position she desired did not exist, and therefore the ADA did not require the employer to provide it. Incredibly deferential approach to employers, basically making part-time accommodations optional, ignoring the fact that the ADA is law, not a list of suggestions, right? This is a reasonable accommodation right, statutory right, not just a suggestion that an employer can take or leave. But effectively what the courts have done is told employers that you do not have to provide a part-time schedule accommodation unless you voluntarily choose to create a part-time position. So that's the first way courts have denied employees the part-time schedule accommodation that the ADA appears to promise. The other way that I mentioned a moment ago is this idea that full-time hours are essential. Courts get this essential language from a portion of the ADA that defines qualified individual. And that qualified individual definition, of course, was designed to be very inclusive, saying that employers have to think about who is qualified by thinking about the types of accommodations that could help them do essential functions. They couldn't deem someone unqualified just because they need reasonable accommodations. The courts, unfortunately, have really distorted the concept of essential function. It's clear from the legislative history, when Congress used the term essential function, they meant job tasks. So things you have to accomplish to do what the reason your job exists. So those might be things like you have to be able to communicate, you have to be able to lift or climb, these types of actual tasks that need to be accomplished for the job's purpose. But courts, unfortunately, have really distorted this concept of essential functions, going so far in this context as to say full-time hours are essential functions. And so using this logic, they say that a person who cannot work full-time hours is not a qualified individual. And some courts go so far as to say, well, then they're just not even covered by the ADA at all, which is really incorrect. But that's the logic they use of saying you're not covered by the ADA unless you're a qualified individual with a disability. They say that if you cannot work full-time, you're not a qualified individual. which really lets the employer off the hook. Now, this clearly is wrong because, of course, the language of the qualified individual definition doesn't just say essential functions. It says essential functions with or without reasonable accommodations. I'm trying to change my slide here. For some reason, I'm not able to change forward the slide. If anybody has
Well, that explains why she couldn't forward her slide. She was booted out. She'll be back. Jeanette, you need to turn on your voice again.
Thank you, Gentle. I appreciate that. All right, my apologies. I think I had an internet problem there that kicked me off. My apologies for that. So I was talking about the second way that courts deny reasonable accommodations, and they do that by deeming full-time hours to be an essential function, which really is incorrect under the text of the ADA, because the text of the ADA doesn't put essential functions as a standalone requirement, right? First of all, as I said before, hopefully you heard this part, was the essential functions really means job tasks, not full-time hours. But once the court even concludes it's full-time hours, that's incorrect because it's essential functions with or without reasonable accommodations, and because the statute makes clear that one type of reasonable accommodation is a part-time schedule, that makes clear that the ADA requires employer to provide a part-time schedule in order to do the reasonable accommodation. Yeah, Electra, you're right. The essential functions are the ability to require for the job, not the full-time hours, right? So the tasks of the job. But what courts are saying is essential functions, full-time hours are essential function, which is definitely wrong, because the statute says part-time hours are something that will enable you to do the essential function. So full-time hours can't be the essential functions, because part-time hours obviously don't enable you to do full-time hours. So the text itself really forecloses this approach. But nonetheless, a lot of courts take this approach, and it's become very, very entrenched in the case law. So to give you an example, a woman who was hired into a 20-hour job and performed very well lost her job when her employer demanded that she more than double her hours. And she made clear to her employer, this is not possible for me. I have fibromyalgia, that I need a part-time schedule in order to manage my energy levels. But the court sided with the employer and said, well, the employer believes that full-time hours are an essential function. And this deference meant the employer didn't have to even explain why it refused to consider hiring a second part-time worker to supplement the plaintiff, even though that probably would have been less expensive for the employer than replacing her with a full-time person who they had to pay more and provide benefits to. So even though there wasn't really a financial justification for the employer's decision, the court took this logic of saying full-time hours are essential to prevent her from succeeding on her claim that the employer ought to have provided her a part-time schedule. So these are the court's stated reasons for denying part-time schedules, and both of them really end up in the same place of making part-time schedules optional for employers, allowing employers to get away with denying part-time schedules without showing an undue hardship as the statute requires. So those are the court's stated reasons for doing this. What I'd like to share with you now is what I think are their unstated reasons, what actually may be going on and driving the court's reasoning here. So my first assumption about what's going on here is status quo bias, right? This is probably not a reason that would be difficult for you to guess, right? There's just such an entrenched 40-hour norm in our culture, 40-plus hour norm in U.S. culture in particular, and the courts are prioritizing the preservation of that norm over the ADA's integration goals. And I can confirm that by looking at the cases and a couple of inconsistencies I'm seeing in how courts are handling accommodation requests. So one of those inconsistencies is a difference in how courts are thinking about standard hours versus really extreme hours. So in one case, a man had a really extreme job. He was working on an oil rig, which required him to work nonstop, 24-hour days for 10 to 12 days nonstop. And he did these 10 to 12 days of nonstop work 2 times per month with a small break in between. And with that kind of extreme level of hours, the court concluded, okay, because he has acquired a disability, it's important that the employer to split the job into 2 in order to accommodate his need for time off to rest and recover. But in the same jurisdiction, when a man who had a 60-hour job similarly said, my disability requires me to have additional time off to rest and recover, the court was very dismissive of the idea that it could divide a 60-hour job into. Said that's not even a plausible accommodation request. Courts has taken a very similar attitude towards shift work, saying that shifts that exceed 12 hours could be subject to an accommodation request, but more standard 8 to 10-hour shifts, courts have said those can't be subject to accommodation requests because 8 to 10-hour shifts, those are standard. And this really, I think, demonstrates what the courts are doing is really prioritizing standard hours dramatically over integration. They're effectively concluding the ADA curbs employers that demand hours that the vast majority of the population can't work, but doesn't curb the employers that demand typical hours that exclude disabled people at higher rates than non-disabled people. So they're very much prioritizing these standard hours and missing the integration purpose of the ADA. So that's one inconsistency that makes me think it's about this entrenched 40-hour norm. That's what they're thinking, as opposed to doing what the ADA requires. The second thing I think is going on is, oh, I'm sorry, actually, I have one other point on inconsistencies. Another inconsistency that I think also shows this entrenched norm is the court's different attitudes toward short-term versus part-time, short-term versus long-term part-time schedules. Courts are far more willing to say the ADA requires temporary part-time hours than long-term part-time hours. And this is a very medicalized kind of time off to recover framework, right? The courts are saying, well, temporary part-time hours can be okay to enable the person to conform to the standard work hour norm. But courts are really reluctant to conclude that they could permanently reduce the hours for a person who has a long-term disability and doesn't expect to be able to conform to the standard hour norm. And in fact, some courts use the analogy of a leave of absence when they're talking about part-time hours. And so they say it would be unreasonable for an employer to provide an indefinite leave of absence to somebody who is completely unable to work for a number of years and their condition is static. naturally, right, the law says employer doesn't have to wait indefinitely for a person's condition to improve if they are completely unable to work. But courts are saying that logic applies even to people who are asking for part-time schedule accommodations, who of course still have quite a bit of work capacity and have a lot to contribute. But the courts are saying, well, the job itself isn't going to change. And so even the part-time schedule accommodation can be temporary in order to be an on-ramp back to full-time work. And if you cannot show that you are going to get back to the full-time schedule, courts are very reluctant to allow it. So again, that short-term versus long-term attitude really shows a prioritization of the status quo over integration, this notion that the job cannot change. The second unstated reason I think that's driving courts' attitude toward part-time schedules is a concern that the ADA might create a privileged class of part-time workers. They're concerned that part-time schedule accommodations might give disabled workers higher quality part-time jobs than the part-time jobs that are generally available. And I see this to some extent reflected in courts' insistence that reducing the hours of a job amounts to creating a new position. Like, they're very reluctant to think about that as just splitting two positions in two. They're saying you're creating something entirely new. And I think a lot of that attitude comes from the idea that we would be creating a part-time position that wouldn't otherwise exist. And in many cases, it's a part-time position that would be higher quality than the part-time positions that are generally available. I see this concern most directly in Family Medical Leave Act cases, where you can use the Family Medical Leave Act, FMLA, to do a reduced schedule leave if you reduce your hours by no more than 25%. And you can do that indefinitely. But employers complain vehemently about this, saying that, well, part-time workers shouldn't get full-time benefits because naturally, in many cases in the U.S., they generally treat part-time workers significantly worse than full-time workers. And so having a statute requiring them to treat someone who isn't working full-time like a full-time employee seems problematic to them, particularly because of the health insurance that the FMLA requires them to continue providing people on a reduced schedule. This thinking really also influences the ADA, which is ironic because the Equal Opportunity Employment Commission has said employers don't have to give workers receiving part-time schedule accommodations the same pay and benefits they give full-time workers. But despite that statement by the EEOC, courts still seem very reluctant and very aware of the fact that part-time jobs are typically not as lucrative, not as don't have the status of full-time jobs, and so they still are very concerned about the part-time schedule accommodation having the effect of creating a prioritized, privileged group of part-time workers. And to give you an example of a case where that comes up, case involving a court of appeals where the worker asked for a part-time position several months after the employer had laid off all of its part-time workers. And even though the plaintiff had been hired into a full-time job, and a recent change in her health status is what necessitated the part-time work request, the court very much was concerned about, well, would this be fair? Because the other part-time workers don't have jobs at all anymore, right? So the concern is the employer operated under a position where they used part-time status as the reason as to prioritize who would be terminated in layoffs. And so they were concerned about giving any part-time schedule accommodations when these other part-time workers had lost their positions. So I think this is what's really going on here. There's a significant status quo bias, and there's the reality that part-time jobs in the United States are typically lower quality, lower status than full-time jobs, and courts are reluctant to conclude the ADA creates higher quality part-time jobs that would otherwise be available. So the question, of course, is where do we go from here with the courts behaving in this way? One thing, of course, is just to emphasize the ADA's text. That's one thing that I hope that my article does for attorneys who are trying to make this argument, maybe also for employees when they're talking to their employers about what the text of the ADA requires. And I'm hoping we can pull courts back to the text. They claim to be textualist. I'd like them to be more textualist in this arena. But the reality is that courts rarely revisit settled precedent, and in these jurisdictions, it's become pretty settled precedent, and just the two approaches of ignoring the text of the ADA have become very entrenched. And I think we may need to think about reforms that are external to the ADA. If we're really going to fulfill the promise of the ADA's part-time schedule accommodation, the course we're on may not get us there. So one potential reform I think would be helpful is to create parity between part-time and full-time work. So, and by parity, I'm talking equal per hour compensation. Currently in the U.S., part-time workers with the same education level as full-time workers, when you control for demographics for education, typically earn about 30% less than their full-time counterparts. And that varies, of course, across industry. Sometimes it's closer to 20% than 30%, but it's a significant difference. And so if the law mandated equal per hour compensation for the same work, I think that would go a long way toward reducing courts' concerns that a part-time schedule accommodation would create a favored class of part-time workers. In addition to creating parity in compensation, we could have parity in benefits, right? Might need to prorate that in a way that would reflect hours worked. So a half-time person might be eligible for promotion after 2 years of service. If a full-time person was eligible for promotion after 1 year, have similar prorated benefits for retirement contributions and job security. I think these types of efforts to create parity would make part-time work more feasible for a wider range of workers. It would normalize part-time work and enhance its status and hopefully alleviate the marginalization of people who are working part-time. Another way, I think, to make things better would be to reduce employer incentives to prefer a small staff working long hours instead of a large staff working small hours. There's a lot of things in the law that really kind of line up with American culture, where the assumption is you'll have a small staff working large hours. So, for example, how we give different businesses small business status, and there's certain benefits and regulatory exemptions that come with being a small business as opposed to a large business. And a lot of times that's based on the number of employees an employer has. And so that creates an incentive for an employer to have a small number of employees as opposed to a larger one. So if we change those and based it on perhaps revenues, profits, or actually the number of hours worked as opposed to the number of employees, that might reduce employers' incentives to prefer long hours. A more significant change, relieving employers the obligation to provide health insurance by adopting a single-payer healthcare system, I think also would reduce employers' incentives to have their employees all work very, very long hours, right? That per employee cost, if that wasn't part of the employer's obligation, they would have a greater incentive to hire more workers and have them work shorter hours if that's what they prefer. Additionally, I think reforming the Fair Labor Standards Act to reduce the number of jobs that are exempt from overtime compensation. If employers had to pay overtime to a larger percentage of their employees, they would have a greater incentive to hire more employees instead of being on the hook for overtime. And then finally, shortening the standard work week to really reflect the work capacity of a wider range of people, I think, is also a significant reform. And countries that have tried this indicate that it really is significant for reducing the marginalization of disabled workers and also, honestly, improving health markers across the board for people who are disabled or not. So I think there are a range of reforms that are worth exploring. And finally, I'll conclude, I think it's worth just sort of dreaming big in terms of even thinking about the language that describes work hours. Throughout this presentation, I've talked about full-time, part-time, half-time, job sharing. But all of that language that I've been using here really centers physically robust workers, right? The notion of full-time really centers the physically robust worker while framing others' efforts as fractions of that norm. And of course, if a 20-hour job demands the vast majority of a person's energy, terms such as part-time or half-time really devalue that contribution. And even the language of job sharing. Sharing is a nice word, but it suggests that people who are working in job sharing arrangements make only a partial contribution, when really they may be giving very much their full effort. And so I think we also should consider more neutral phrasing, like just calling it a 40-hour job or a 20-hour job may help reduce the marginalization of people who are working fewer than average jobs. I will end there, and I look forward to your questions and dialogue. Thank you.
Wow. Jeanette, this is Jenna again. You've certainly given us a lot to think about. I want to start with the question, how did you get interested in this particular area of disability law?
Yeah, so I've been interested in disability law in a broad sense for a long time. My sister has Down syndrome. But then this particular area of disability law arose from a period of chronic illness I experienced, where I was, fortunately because of the type of work I do, I was able to self-accommodate more than most people can in other types of work. But I had a chronic illness that lasted for seven to 8 years, depending how I count, and that really made me very aware of how restrictive work options are, right? I was part of a Facebook community of other people experiencing chronic illness, and just the work issue was a really big one. I was incredibly fortunate that I didn't have to quit my job. But if I'd had other types of work, as opposed to being an academic, certainly if I had worked in a standard law firm position, there's no way I could have kept my job through that period of time. So that really was what drove my interest in this topic.
Jeanette, Mook asks, there's very disturbing news about an institution which is supposed to stand up for the rights of the ordinary citizen. Would you know, are these conflicts between court judgments and the ADA clauses happening all over the U.S. or just in certain places? Is this change in direction recent? And do you think this new behavior by the courts is politically motivated? You don't have to answer that last question if you'd prefer.
Yeah, thank you for that question. So it's not everywhere. There are some courts, and it's actually interesting. I mean, it's somewhat what you would expect in terms of liberal and conservative portions of the country. I would say that the courts that have been most rigidly against part-time schedule accommodations are the Seventh Circuit, which is Chicagoland and states surrounding, and the 11th Circuit, which is Florida, Georgia, and that region. Those are the courts that have been most against part-time schedule accommodations. Although I occasionally, see things from surprising places. So it's a mix, and courts are not entirely consistent in how they handle this either. And it's not entirely recent. I would say, I guess in the Fourth Circuit, which is Virginia, that area, there have been some recent shifts. So the recent case about job sharing just came out of the Fourth Circuit. So I guess I've seen some changes there, which may somewhat be connected to the change in composition of the court. I mean, it's no secret that Trump appointed a lot of very far to the right federal judges, and obviously Biden's at the moment trying to counteract that. But just in terms of the numbers, that Biden has not appointed nearly as many, and so there are courts that are certainly leaning in a more conservative direction now. So that's another reason why I am concerned going forward. Thank you for that question.
Jeanette, Pecos Kid asks, how does the recent rapid increase in work from home jobs factor into this discussion?
Yeah, if you're interested, I have a colleague who wrote a really comprehensive article recently about remote work, which, yeah, so I'm not the expert on that. Arlene Cantor is the expert on that question. But I do think work from home, in terms of its relationship to part-time, it's really significant, because a lot of the expense of part-time arguably is just, you know, equipment, supervision kind of expenses. And if you're working from home, a lot of those expenses are not part of the employer's responsibility anymore. So I do think the availability of remote work makes it more feasible to employ people at various different hour levels instead of making it all standardized as it has been historically.
Thanks, Jeanette. Orange Planer asks, based on your analysis, it seems as though people like me who are temporarily prevented from driving to work are SOL when asking for an accommodation to work from home. Is that your take? What steps could I take to force work to approve the accommodation?
Yeah, so I'll recommend Arlene Cantor's article to you as well. I think working from home is separate from the part-time issue. And I have seen some significant movement in a positive direction, you know, post-pandemic about work from home. It's not uniformly positive, but it's definitely quite different than it was pre-pandemic. Pre-pandemic, there was a lot of reluctance for work from to approve work from home accommodations in the courts. These days, a lot of it, I mean, as long as the job is one that easily can be done at home, I think the argument for allowing remote work is much, much stronger.
Jeanette Gentle asks, as he signed the ADA into law, President George H.W. Bush said, "Let the shameful wall of exclusion finally come tumbling down." You pointed out several walls that still exist. What can we do as a virtual world community to help bring those walls down?
Well, my impression is you are doing a lot, Gentle. I don't know the full the full extent of what you're doing, but certainly you're using this environment to make things possible that wouldn't otherwise be possible. So I guess the challenge is, you know, communicating that to other communities, folks who aren't connected to your community, to see what's possible. I think that's part of it. So maybe inviting more people into your community, seeing the creative approaches that you have come up with, I think is one step that might be beneficial.
Jeanette, Orange is asking for a link to Arlene's article.
I believe I can come up with that for you. Yeah, sure. If I put that in nearby chat, will that work, or should I put that someplace else?
I think that works great.
Okay.
Yep. Thank you for that.
You're welcome.
Jeanette Mook says, your information has reached many countries today. We are a very international audience.
Yeah, and I'm curious. So I don't know where you all are, but what's your impression of the law related to part-time accommodations where you are?
And if you would all just put your locations in chat, that will help Jeanette understand the audience.
So Idiko says, I am in Wisconsin, enough said, haha. Orange is in the Netherlands, Mook is in the UK, Lori Vaughn is in Nova Scotia, Canada. And Ice Guy says, yeah, Idiko, yep. Lynn is in East Coast, United States. Orange says, does Arizona still count as a state?
All right, so yeah, quite a range.
Says V is in Malaysia. And Ice Guy says, I call Wisconsin the North Coast. Across Lake Superior to Canada, yay. Pecos is in the country of Texas. Orange says, I was counting you, Vulcan. Lauren is in scintillating Turlock, California. Electra is in Italy and says there's a similar mentality in Italy. Not sure about part-time accommodation, but remote jobs were recalled, even in cases where going to the office doesn't really improve things, especially with the cost of gas now. And Vulcan is in the Netherlands.
And we certainly are in an interesting dynamic right now where seems to be a lot of people have this huge impulse to return to normalcy, whatever that is, pre-pandemic, even when, it doesn't really seem to have much benefit. It seems like there's some lessons we learned from the pandemic we could hold on to, but it's been a challenge.
Ches says that Exie and I are also New England, and Orange says, yeah, I'm in Massachusetts. Gentle says normal or prior normal is not necessarily better.
Agreed.
And Itica says, for those who do not know, Wisconsin is a state which is trying to hold on to a past that never existed in a good way for disabled people. And Orange says, in my case, the COO is old school. He thinks that if people aren't physically at work, they aren't working. And Ice Guy says the pre-pandemic normal was not working. Going back to it is not going to work either. And
it's so interesting because there's all that research about how much more productive we were when we were all working at home. So.
Slayton says in Italy, it's called smart working, quite hilarious. And Lori Vaughn says, focus on the work done and not where and when it is done. Orange says, there were a few bad apples in 2020, 2021, and that's poisoned his attitude. Talking about this again. Electra says, indeed, that's the problem, I think, a very old and or set in their ways employer.
I would say that's really one of the core problems with the law in the U.S. is this notion of what's essential. And, courts agreeing with the old school employers that all of the ways that they've structured work are essential, even though those are some of the exact structural things that the ADA was designed to get rid of, or at least create flexibility around.
Okay, Rhiannon says, I really feel one of the only good things to come out of COVID is that folks could work remotely, and hopefully more job places embrace this. Ice Guy says, we have very old set in their ways politicians running around, and I'm not being ageist about it. It's the old school mentality of too many of them. A few are more forward thinking, but they're a small minority. And Gentle says that could be used to justify slavery. Lynn says, I can't help wondering about all the employers who don't provide benefits for those not working full time. Not precisely on this topic, but related. And Ori says gentle, which is in some states still legal. And Lauren says, Okay, and I think we have time for one more question. Pecos asks, are there many positive examples, though, companies that fully embrace part-time work and similar accommodations and can show improved success because of their approach?
Yeah, I'm afraid I'm guilty of focusing on the negative. I'm looking at the cases that actually get litigated, right, where the employer digs in their heels and insists on going to court. Certainly, yeah, there are a lot of employers who are doing a nice job with this. So it's not universally bad news. I'm just very much looking at the cases that actually go to court, and a lot of employers really try to work with people and find good solutions. And so you certainly see examples of employers that do a nice job with this.
Marcus brought in a comment from YouTube. Sherkin Change Heart. I don't think old as in aged is the issue. Closed minds, fear of change, and other emotional structures are highly active in the inflexible viewpoints that some decision makers hold. And Lori Bond says, Ice Guy, you are one of the hardest working people I know. And Electra agrees with Shirkin. Exie says, Industrial Revolution factory hours don't really work for today's world and the jobs available today. And Namara nods. Gentle says, we probably need to highlight the positive examples as models. And Mook says, how many of these disputes never get to court? Many people get too stressed to pursue these injustices or cannot afford it.
Yeah, that's a good point, Mook. I mean, I'm probably looking at, less than 1%. Probably, 0.01% of the actual, disputes actually get to this stage where you have a written judicial opinion, right? Most of them get resolved one way or the other, right? The employer does the right thing or the employee gives up, right? One way or the other. That's what's happening most of the time, and it's hard to research what's happening in those contexts.
Yeah, Ice Guy says, or are too intimidated to go forward.
Sure.
Don't know how to go about starting a class action suit.
Yeah, class action suits are really difficult for the ADA because courts have required there to be such a similarity amongst all the members of the class. And so that's always been a challenge with disability, is because it's a rare circumstance where there's a very large group of people who have a similar enough set of needed accommodations. Oftentimes when it's a group that needs slightly different accommodations because they don't all have the exact same disability, courts are unwilling to let them form a class action. So that's always been a challenge for enforcement, because you're right, it's expensive to go as an individual, so you'd like to join with a group, but it's always been hard in the disability context.
Okay, Jeanette, I think maybe what we'll do is close at this point. This has been just a wonderful, very informative, rich presentation. So we just want to thank you so much for joining us here in Second Life.
Thank you. I really enjoyed being with you. I'm sorry for my technical issues, but thank you for hanging with me.
Yeah, that happens a lot, so don't you worry about that. Everybody, we have a musical interlude right now, and then at 1 p.m. We'll be having Nick talk about injustice in hiring. So join us for that session. And thanks again, everyone.
Thank you very much, Jeanette. That was wonderful.
Thank you, Gentle. I really appreciate it. Appreciate the invitation to be here.